If a cop ever says those 5 words, "Let me see your phone," and you don't know this one phrase, you could hand over every secret, every conversation, every photo, every financial record you own, all in a single moment, without even realizing you just gave it away. What you say in the next 5 seconds either protects your entire life or destroys it. And most people get it completely wrong. If this is the kind of knowledge you want in your corner, hit subscribe right now, because we break down your legal rights in plain language. No law degree needed. And new videos are dropping every week that could save you from a situation you never saw coming. Picture a regular Tuesday. You are coming from work. You get pulled over because your tail light is out. That is it. Routine stop. Then the officer leans in and sees your phone on the passenger seat and says, "Were you texting while driving?" You say no. Then the officer says, "Let me just take a quick look to confirm." And right there, that moment, most people hand it over. Not because they are criminals. Not because they did anything wrong. Because they are nervous. Because they want to seem cooperative. Because they think saying no will make things worse. And because nobody ever taught them what handing that phone over actually means. Here is the phrase you need memorized before you ever need it. Say this out loud right now, so your mouth knows it before your heart starts racing. "Officer, I do not consent to any search of my phone." That is it. 7 words that carry the full weight of constitutional law behind them. But before we go deeper into exactly when to say it, how to say it, and what comes after, you need to understand why this moment is so dangerous in the first place. What most people do not know is that your phone is not like your glove compartment. Your phone is your entire life compressed into a rectangle. It has your texts going back years. It has your location history. It has your photos, your bank apps, your emails, your notes, your contacts, your search history. The Supreme Court of the United States recognized this in Riley v. California, and in plain English what that ruling says is this: police generally need a warrant to search the digital contents of your phone, even after an arrest. Your phone is treated as a private zone so extensive that even getting arrested does not automatically give them the right to go through it. That is how significant this is. And yet people unlock their phones for officers every single day because they do not know they can say no. The first tactic you need is how to shut down the casual glance trap. This is the most common version of the phone encounter. The officer will make it sound like absolutely nothing. They will say, "Just show me your messages real quick," or "Let me see your photos from earlier." They are making it feel the same as handing over your driver's license. It is not the same. Not even close. Your license is a piece of plastic with your name on it. Your phone is a window into every private corner of your existence. So here is exactly what you say, word for word. "Officer, I do not consent to any search of my phone." Memorize that. Write it down if you have to. Then follow it immediately with this: "I am happy to cooperate, but I do not consent." That second sentence matters because it keeps your tone cooperative while your boundary stays firm. You are not being aggressive. You are not being dramatic. You are being precise. This works because consent is their easiest shortcut. In Schneckloth v. Bustamante, the Supreme Court ruled that consent to a search can be valid even if you did not know you had the right to refuse. Read that again. You can lose your Fourth Amendment rights simply by not knowing you had them, and saying yes out of fear. That is the gap your "I do not consent" closes. The moment you say those words clearly, their easiest path is gone. Defense attorneys use this exact language in court because it creates a clear, documented refusal. It shows no agreement was given. And it keeps you from filling the silence with explanations that accidentally make things worse. Here is what worse looks like. Most people say, "Yeah, go ahead. I have nothing to hide. Then the officer scrolls, finds a photo or a text that looks suspicious even if it is totally innocent, and a routine stop becomes a case. Here is what smart looks like. You say, "Officer, I do not consent to any search of my phone." You repeat it calmly if asked again. Same words, same tone. No extra explanation. No rambling about why your texts are private. No offering to show. Just one thing. The moment you negotiate, you invite a bigger search. And if the officer tries the guilt move, "If you have nothing to hide, you will just show me," do not fall for it. That is a shame push. It is designed to make you feel like invoking your rights is somehow suspicious. Your rights are not a reward you earn by being innocent. They are yours before any question is ever asked. Stay calm. Repeat your line. Have you ever been in a stop where an officer asked to see your phone? Drop in the comments exactly what they said, because your experience might help someone else watching. The second tactic is the one that destroys people the most, the unlock request. Once you decline the casual look, many officers will shift to a different angle. They will say, "Okay, just unlock it for me." Or, "Just hold it up to your face real quick." Or, "Type your passcode so I can confirm the device is yours." That sounds almost reasonable. It is not. Unlocking is not a small step. Unlocking is you opening the vault and handing them the key. Here is exactly what you say when they ask you to unlock it. "Officer, I do not consent to unlocking my phone." Memorize that line. Then follow it with exactly 5 words. "I choose to remain silent." If the pressure continues, you add, "I will not answer questions without a lawyer." That sequence, refusal, silence, lawyer, is your full shield. Do not pick and choose from it. Use all 3 when things are escalating. This matters because unlocking your phone is not just about one screen. It is about everything that can be extracted, downloaded, or observed once the lock is gone. Your messages, your location, your deleted files that can often still be recovered, your app history, your private notes you wrote to yourself at 2 in the morning. Once that lock is gone, so is your control. That is exactly why Riley versus California exists. The court understood that searching a phone after an arrest without a warrant is not like checking your pockets. It is like seizing a filing cabinet, a journal, a map of everywhere you have ever been, and a recording of every conversation you have ever had, all at once. Your passcode is the last line between all of that and them. Here is what the wrong move costs. Someone says, "Fine, I'll just unlock it so we can move on." The officer reads a private message out loud. Something that sounded innocent in context sounds completely different standing on a roadside. Now they are asking follow-up questions. Now your stop is stretched from 3 minutes to 45. Here is what the right move looks like. "Officer, I do not consent to unlocking my phone. I choose to remain silent." And then you stop talking. Because here is the truth most people refuse to accept. You cannot talk your way into safety once your phone is the target. You can only talk your way into giving them more material. They may try to sweeten it. They might say, "Help me help you," or, "If you just show me, I will let you go." That is a deal trap, and it is effective because you are scared and you want the discomfort to end. Former law enforcement professionals have confirmed openly that this works on people because the relief of the stress ending feels more real than the risk of what comes after. So you do not chase their offer. You hold your line. You also do not start touching your phone, deleting anything, scrolling fast, or hiding apps. That creates new problems. Your phone stays where it is. Your mouth stays closed. The third tactic covers what happens when they try the phone hold move. This is a subtle escalation. The officer does not ask to search your phone anymore. Instead they say, I am not going to search it. I am just going to hold on to it while we sort this out. Or, we are going to secure it for now. That sounds softer. But once your phone leaves your hands, you have lost control. And once you are tired and embarrassed standing on a curb with no phone, they come back and say, just unlock it, and I will give it right back. And that is when people cave. Here is exactly what you say the moment they reach for your phone. Officer, am I being detained or am I free to leave? 9 words. Memorize them. Then follow with, I do not consent to you taking my phone. If they say they are taking it anyway, you say clearly, if you take my phone, I want a receipt for it. Calm voice. No physical resistance. Just words. This approach does 3 things simultaneously. It forces clarity about whether you are actually detained. It documents your non-consent for any future legal proceeding. And it creates a paper trail on your property. You are not grabbing your phone back. You are not raising your voice. You are building a record. Because what happens in the next 60 seconds on that roadside matters months later in a courtroom. There is also a time angle here that works in your favor. Traffic stops are not indefinitely expandable. The Supreme Court addressed this in Rodriguez versus United States, and in plain English it means officers cannot stretch a traffic stop beyond what is reasonably necessary for the original purpose without independent justification. Am I being detained or am I free to leave? Question directly challenges that stretch. It marks the moment you push back on the delay. And it matters. The 4th tactic is for when things have gone past the roadside and you are in custody. Maybe you are in cuffs. Maybe you are in the back of a patrol car. Maybe you are in a room at a station being told that cooperation will make this go much faster. This is the comfort trap, and it is the most psychologically sophisticated one. They act warm. They act like your phone is already theirs to deal with. They imply that unlocking it will make you look better. This is precisely when you need the clearest words you have. Here is exactly what you say. I want a lawyer. 4 words. That is your full statement. Follow it with, I will not answer questions without my lawyer. And if they keep talking at you, you say, I am choosing to remain silent. Then you stop. You do not explain. You do not clarify. You do not fill the silence because silence is not an admission. Talking is the risk. The legal foundation for this is Edwards versus Arizona. In plain English, if you clearly invoke your right to an attorney during custodial questioning, interrogation is supposed to stop until a lawyer is present. But the word clearly matters here. Saying, maybe I should talk to someone, does not protect you the same way. Saying, do I need a lawyer, does not trigger the same protection. You say, I want a lawyer, with no hedging, no question mark, no conditional. That is your stop sign, and it has to be planted clearly. And there is one more layer. Remaining silent is not automatically protected unless you invoke it out loud. This connects to Burgess versus Tompkins, which in plain English means that sitting silently without ever saying you are invoking your right to silence might not be enough. You need to actually say, I am choosing to remain silent. Say it once. Then live by it. Now let us bring the legal framework together in language your brain will actually hold onto under pressure. Riley versus California means your phone has a privacy wall around it, and police generally need a warrant to breach it. Schneckloth versus Bustamante means your yes erases that wall instantly, which is why you never say yes. Rodriguez versus United States means they cannot hold you at a traffic stop indefinitely without a real reason, which is why you ask if you are being detained. Edwards versus Arizona means invoking your lawyer shuts down custodial questioning, which is why you say those 4 words clearly. Burgess versus Tompkins means you must say out loud that you are remaining silent. Put it all together, and every single tactic you just learned flows from one consistent strategy. Do not consent. Do not provide words that fill in the blanks. And do not let nerves override the rights you were born with. Let us walk through a real scenario, so your brain can rehearse it. You get pulled over for rolling through a stop sign. Officer approaches. Sees your phone on the seat. Says, "Were you on your phone?" Wrong way. You say, "No, I was just checking a notification." Officer says, "Let me just verify." You hand it over and unlock it. Officer sees a text thread that mentions a bar you were at. Now officer is asking about your drinking. What started as a 3-minute stop is now a field sobriety situation. Right way. Officer says, "Were you on your phone?" You say, "Officer, I choose to remain silent." Officer says, "Let me see your phone." You say, "Officer, I do not consent to any search of my phone." Officer says, "Just unlock it for a second." You say, "Officer, I do not consent to unlocking my phone." Officer reaches for it. You say, "Am I being detained or am I free to leave?" Officer says you are being detained. You say, "What is the reason I am being detained?" Officer says they are securing the phone. You say, "If you take my phone, I want a receipt for it." That is the right way. Calm, consistent, documented. No aggression. No rambling. Just your rights, exercised clearly. Here is your recall list for when your heart is pounding and you need it fast. To block the casual search, you say, "Officer, I do not consent to any search of my phone." To block the unlock request, you say, "Officer, I do not consent to unlocking my phone. I choose to remain silent." To challenge the detention and the phone hold, you say, "Am I being detained or am I free to leave? I do not consent to you taking my phone." If they take it anyway, you say, "I want a receipt for my phone." If you end up in custody, you say, "I want a lawyer. I will not answer questions without my lawyer. I am choosing to remain silent." Knowing your rights is only half of it. Using them at the exact right moment, under pressure, with a calm voice and no hesitation, that is the other half. And that comes from hearing this, practicing it, and coming back for more. Subscribe to this channel right now, because we are releasing videos every week on exactly how to use your rights in real situations. Traffic stops, searches, arrests, landlord disputes, workplace rights, all of it explained in plain English so you know exactly what to say when it matters most. Your rights are only as powerful as your ability to use them. Stay subscribed, stay informed, and stay protected.